This case starts like so many others, a routine court appearance, a request for more time, and a defendant standing quietly beside his attorney. But within minutes, everything unravels. What was supposed to be negotiations turns into a deep dive into drug use, dishonesty, and a judge who makes one thing crystal clear: lie to the court, and there will be consequences. As the questions get sharper and the answers start to shift, the courtroom transforms from procedural to personal. And by the end of this hearing, one decision changes everything. Stay with us, because what you're about to hear is a masterclass in how quickly things can go wrong when credibility disappears.
And Assistant Public Defender Chinazi Kyriakin on behalf of Mr. Patrick Lake.
And Patrick Hansley.
Your Honor, we are asking for an adjournment. We are in negotiations with the people and yet to reach a resolution.
Pardon?
We are asking for an adjournment, Your Honor, for purposes of further negotiation.
Oh. So what do I do about his violation?
Oh. Give me a second. I apologize, Your Honor, I did not. Yesterday?
Yeah, did you go yesterday, right?
Yes, I did.
He
I'm
said
sorry.
he did. Did he text?
I did.
What was the result?
Oh, they were positive.
Four?
I mean,
For what?
Amphetamine, Your Honor, he says. The court mind passing this, I did not know
I
about.
do.
Yeah, let me,
I do mind passing it.
no, she
Did you test? Hold it. No, I'm not passing it.
okay.
Did you go over and test?
Yes, I did. And she stated that she made a motion to the courts of retracting her violation because that she made the motion towards not retracting, but like recalling the violation request, and they granted her it, she said. Ms. Dozier,
They did what?
they granted like she requested for okay.
So, Your Honor, it looks like Ms. Dozier sent an email.
Okay.
Indicating that there was a violation for his failure to contact community corrections. And then she sent another email on Wednesday indicating, good morning, I sent a violation report for Patrick Lay, closing supervision interest due to failure to report to community corrections. He did make contact this morning after his mom made him aware that I called. He scheduled an intake at 1:30. So this is where he now states that he did go and test at the 1:30 time, or he went to do his intake at 1:30. You said.
And he tested.
Yeah,
she did.
And that's what I want to get to. He
Yep.
tested. And
According
was
to his
positive.
statements today, Your Honor, he indicates that he was positive for amphetamines.
and do you have medication that you take?
I do not, Your Honor.
Okay, that's going to be a problem.
And just message with
And I
Ms.
have to
Dozier,
disclose that
she
to her.
confirmed that his test indicated that he's positive for amphetamines, so now I asked that the follow-up question is explanation for that, and I got the little bubbles that she's typing right now.
Okay. And I was this I was about to.
This makes me jumpy.
So, Your Honor, Mr. Lay indicates that he did have a conversation with Ms. Dozier after the positive test. Ms. Dozier is hopefully going to be able to refer him to CCOP, is what he's saying. He says that they discussed treatment options or things that would kind of help him, I think, based on the underlying offense. The 1298 is a possession charge. I think that we should absolutely focus or try and see how we can get Mr. Lay connected with substance abuse services.
When's the last time you used?
The day of my arrest, of October, October 30th, 10/29, sorry, 10/29/24.
On the 24th?
No, on the,
10/29/24, Your Honor. This is the date of his
So,
arrest for the.
and then you were told on the 30th, you're saying you used before then,
yeah, I used that day. I used that day.
the 29th?
Yeah.
And not, okay, young man.
What?
And not since then?
No, I have not since then. I mean, that's what, that's, okay, I did, okay, I took it.
Yeah, okay, so hold on,
Ritalin.
before you start, hold on,
Okay, sir.
hold on.
Okay,
The one thing about me is I hate when people lie to me.
okay,
I really do.
okay. All right.
So, okay, so hold on. So make sure what you're gonna tell me is the truth, Mr. Allen.
So the last time I used Adderall was about 3 days ago.
Yeah.
That's the truth, Your Honor.
So why were you going to lie to me that it was the day of your arrest?
That would not, that was,
Why were you going
guess-
to lie to me
I guess-
that it was the day of your arrest? I can exactly tell you why you
I'm
didn't
scared.
tell me that.
Your Honor.
Yeah, you were scared, but why were you gonna try to give me the day of your arrest?
I guess.
Because that would have been before you were told by the court not to use.
Okay, well, yes, Your Honor. Your Honor, yep. And yes, also, when I did get out of, bail, or holding, I guess I didn't get sent home with the paperwork saying that I was able, I had a test 24 hours after my thing, after I got released, which I didn't have with all my paperwork.
You
when-
realize we're past that now.
Okay, okay.
I understand maybe why you didn't show up. What I don't understand is why you were using. And then I don't even further understand after using, getting and testing then positive. And then when I asked you a question regarding it, you lied to me.
Okay, I guess I was scared, Your Honor, for the sake of, well, one, I had to show up because it was better to show up and I guess maybe fail and just still be here. Because I know a no-show is also testing positive as well, the same thing. But I wanted to insert myself in like, I want to make myself better. And I want help because I need help, Your Honor. The lying part, I'm shameful for. I'm just, like I said, I'm scared. So I do want help. Why I went to Affirmative Corrections when I was told I'm into zero.
Are you sure it was 3 days ago? Because as I'm listening to you, I think you took it well after that 3 days.
Oh, sorry, I'm just scared. I really am. I'm honest, sir. Like for 3 days, that's when I last took Adderall. I mean, okay, well, I didn't take it. I haven't taken any today. I mean, like 2 or 3 days ago would be like the minimum.
So it was 2 or 3 days.
I mean, I haven't. Okay, so what did?
You want to know why?
I'm sorry, it wouldn't be any less than 2 days ago.
Today's the 7th.
Okay, so Tuesday. I guess it would have been Tuesday. It would have been Tuesday. I didn't look at the dates.
So that's 2 days ago, not 3.
I'm sorry, I didn't really look at the dates. I'm sorry.
Pardon?
I didn't look at the dates and I didn't know like exactly how to reference. I'm sorry. That is the truthful answer, Your Honor. I'm just nervous.
So that's the truth now,
It is the truth.
after 2
Also-
attempts.
No, the second time was not like meant to be a lie. It's just I didn't really calculate the day exactly.
You're.
I'm sorry, sir. That is the
okay.
truth. That is the
Okay.
truth.
It's okay.
There's no other like answer that I can give you. That's. I'm sorry. I'm just very nervous.
Me too.
Your Honor, if I may.
Please.
Yes. Your Honor, I obviously I understand exactly how, what position the court is in right now.
Me?
Mr. No, well, as
I'm in the
your
same position
options.
as when I walked
available.
out.
This is
He's in a
true.
worse one.
This is
But
absolutely.
go ahead, I'm listening.
Your Honor, Mr. Lay is here today. When he was told to come to community corrections, he came, knowing that it was very likely that he would test positive, but was willing to deal with the outcomes because he understands that it's important that he appears to court and he makes sure that he abides by the requirement to come to court. He has an addiction based on our underlying crime and these new bond violations. I'm asking the court to consider at least getting him into the CCOP program as soon as possible. Any other outpatient treatment program available to him. He's not a flight risk. He's here. He's here. He came to community corrections. He's come to court. I know that the people will say that one of his charges are an R&O, which is problematic in and of itself. However,
The other one's in the possession of the drugs
and then the other, that's
that he
correct.
was using after being told not to. Go ahead, I didn't mean to interrupt. I was
That's
just
okay,
trying
Your
to
Honor.
make it straight.
We're just asking for the court's consideration. I know traditionally in this type of situation, the court would consider a remand. We're asking that the court reconsider that and at least allow or order my client to get into some type of treatment immediately.
Well, while you can sit up there and arrange that, that's fine, but I'm not gonna have somebody not only use after being told not to, then lie to me about you.
I didn't mean to like, okay, I'm sorry, sir. I do need help with it. I'm genuinely seeking it. That's why I came to community corrections regardless of my fear or not.
So where are you seeking help?
I'm seeking help for resources of like people that like, I guess you can't really change. You can't change yourself until you change like how you go about like being happy. So I'm just seeking new opportunities, whether it be via work or new outlets of like people that are positive in my life, that are much stronger based on their efforts they made to become sober, and become happy in life again, fulfilled. I'm just seeking help as far as just being around people that can guide me and support me through becoming sober.
So have you found any?
What? I have not, like genuinely, no. I'm not saying I don't really have a lot of friends anymore or support. My family is a good support. I'm really close to my family still. I'm in good terms with them.
Have you asked them to find you help?
I've asked them about moving back in with them. They live in West Spring.
Have you asked about finding help?
They said they would be 100% supportive of helping.
Pardon?
Yes, I've talked to them recently about that, within the last like 2 weeks. And they said they would be supportive of finding.
Have you called any place to try to get into any treatment, young man?
I just got like links and numbers from Mr. Ozier yesterday.
So prior to you going to community corrections, you hadn't done anything?
I guess not, Your Honor.
Yeah.
But going to community corrections was my first step into like realizing that like stuff needs to change my life. And it really does.
You know what?
Does need.
You know what? You need to stop
I know.
because you haven't done anything.
I know.
And that would have been the answer to my question. I don't know why you're trying to make everything when I ask you a question something more than what it is.
I'm sorry.
You haven't done anything. You continued using. That's where you are. So until such time as you decide to be honest about it, nothing's going to work anyway.
I think it might. I know it will. I know it will because I can't risk myself not benefit, like myself growing. Like I'm not gonna risk that. Like I would not like to risk that. I think I'm stronger than I am. Truly, sir. I know I am.
I'll adjourn probable cause to next week, November 14th, 2024 at 9 a.m. At this time, defendant's bond is revoked. You're remanded.
Thank you, Your Honor.
Yes.
By the time this hearing reaches its conclusion, the outcome feels both inevitable and instructive. Let's break down what actually happened here, because this case isn't just about drug use. It's about honesty, accountability, and how the court evaluates trust when someone is released on bond. At the start, the defense asks for an adjournment, explaining that negotiations are ongoing. That request alone isn't unusual. Courts grant adjournments every day. But almost immediately, the focus shifts to a violation tied to community corrections, specifically a failure to report followed by a late intake and a positive drug test for amphetamines. Okay. Here's the first critical legal issue. Bond conditions are not suggestions. When a judge releases someone pre-trial, they are effectively extending trust. In exchange, the defendant must follow strict rules, including reporting as directed and not using controlled substances. Once the defendant tested positive, the court wasn't just dealing with addiction, it was dealing with a breach of that trust. What escalated this situation wasn't merely the positive test, it was the inconsistent statements that followed. When the judge asked a direct question about the last time drugs were used, the answer changed. First, it was the day of the arrest. Then it became 3 days prior, then 2 days. Each adjustment chipped away at credibility. Judges are trained to spot patterns, and shifting timelines are one of the biggest red flags in courtroom testimony. The judge makes something very clear during this exchange. Drug use is serious, but dishonesty is often worse. Courts can work with people who struggle. They cannot work with people they believe are being deceptive. That distinction matters. The judge even acknowledges understanding fear and addiction, but draws a hard line when it comes to lying directly to the court. The defense attorney does what defense counsel is supposed to do, advocate. She emphasizes that the defendant did show up, did report, and did not flee. She highlights addiction as the underlying issue and asks the court to consider treatment options instead of incarceration. From a legal standpoint, this is a reasonable request, especially when rehabilitation programs like CCOP exist specifically for these circumstances. Okay. But here's where the balance tips. When asked what steps the defendant has taken on his own to seek treatment, the answer is essentially none. No calls, no intake appointments, no proactive effort before the violation. In the court's eyes, intent matters, but action matters more. Saying you want help is not the same as pursuing it. The judge ultimately revokes bond and orders remand. That decision isn't about punishment, it's about control and compliance. Once the court believes a defendant cannot or will not follow conditions while free, custody becomes the only remaining option to ensure appearance and safety. So here's the bigger takeaway. This case is a powerful reminder that the courtroom is not just about charges, it's about credibility. Every answer matters, every inconsistency matters. And once trust is lost, even strong arguments for treatment can fall flat. Okay. Now we want to hear from you. Do you think the judge made the right call by remanding the defendant? Should treatment have been prioritized despite the lies? Or did the shifting story leave the court with no other choice? Drop your thoughts in the comments, because cases like this sit right at the intersection of accountability and compassion. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you in the next case.